Okay, the next case on our docket is 23-4158 Dawson Parton Carbell Calderon versus State of Florida. Appellant's counsel, are you ready to proceed?
Yes, Your Honor.
Okay, and how much time would you like for rebuttal?
I would ask for 5 minutes rebuttal and reserve any remaining time, Your Honor.
Okay, thank you. And you may begin.
Good morning, Your Honor. My name is Brendan Mula. I represent Dawson Parton Calderon with Mr. Ali and Zach Starnbos seated at council table. Your Honor, this incident initially occurred on June 14th, 2021, which there was a battery. My client, Mr. Calderon, was the defendant in that matter. Following that, there was a subsequent battery that occurred in 2022 in which the alleged victim's son was involved in the battery. In that matter, there was a vehicular accident. A pickup truck crashed into Mr. Calderon's four-wheeler, resulting in injuries. That case was subsequently no infoed by the state. Following this, in December of 2022, Mr. Calderon pled to the lesser included offense of battery, not battery on a person of 65 years or older, but a simple battery or unwanted touching. Following that, there was a restitution hearing held to determine how much restitution Mr. Calderon would be liable. In that hearing, that was conducted in 3 parts. The initial hearing was done in July, September, and the final ruling came out in October of 2023. During that hearing, Mr. Calderon, or Mr. O'Berry, the alleged victim, had testified that he sustained injuries that made him unable to work, and also submitted medical records and bills to the court over defense's objection for hearsay. It is important to note too before this court that the medical bills provided, as well as the medical treatment rendered to Mr. O'Berry, occurred about 18 months after the initial battery, some of which within 6 months of the restitution hearing. And this timeline is very important for one reason and one reason only. That is the issue of causation. Now, in determining whether or not to grant an order of restitution, there are 2 things that need to be determined: whether or not it is substantially related, and whether or not there is causation to the underlying criminal offense. I would proffer to this court that while it is possible that someone who has injuries from a battery can be in fact injured, there is a lack of a causal relationship. The case law is very clear in that it likens restitution orders and causation to tort law, meaning there needs to be proximate cause and an actual cause, or but-for causation. I would proffer to this court that there is no proximate cause, nor is there any evidence of but-for causation as provided on the record. In the instant case, we have a battery that occurred in 2021 and a separate battery that occurred in 2022. That one resulted in injuries.
I thought I remember reading that the injuries were to the other party in the second incident.
It's my understanding that Mr. O'Berry was injured. He was riding on a four-wheeler that was crashed into by his son riding a pickup truck, and he had injuries that he sustained to his face, and he crashed his face down in the windshield area. Now, with regard to but-for causation, the record is silent as to any actual but-for causation, whether or not the injuries were caused by the first battery.
What would be required in your position? What is your position as to what's required to meet proximate cause and but-for? Is it not enough for the victim to get up and say, I think he said at one point, I remember reading, well, I'm wearing this hearing aid now and I could hear fine before the incident. Like, that's not enough?
I would argue it's not, Your Honor, especially given the circumstances of the case. Mr. Calderon, or Mr. O'Berry, excuse me, at the time of the incident was 75 years of age. He was getting pretty up there, and a lot of these injuries could have been, in fact, caused by the natural aging process or by what happened during the second incident.
Is there something under the law that tells us we would need something more than his testimony? I mean, say, say he says, for example, I've never had arm pain before the accident. The accident happened, I immediately had arm pain, right? And I know that that's just hypothetically, right? But if he says that, couldn't the finder of fact take that as evidence related to causation? And if not, if that's insufficient, Is there something under Florida law that tells us that's insufficient?
Under Edwards v. State and Coley v. State, there needs to be substantial and competent evidence.
Mhm.
This is just testimony from the alleged victim in of itself. While his credibility was not assessed at the lower court's hearing, he is the opposite party, and I will get into that more when I get to the next point regarding the hearsay arguments.
What do you mean his credibility wasn't assessed?
There was never a finding of credibility on the court's ruling on October 25th of 2023.
I mean, the trial judge didn't state a ruling.
Correct.
Is that required that
No,
that
Your
the
Honor.
trial judge make a statement on whether a particular witness was credible or not?
No, Your Honor.
Can you talk, counsel, about the role of hearsay in restitution hearings? There's certainly a statute on point, and it seems to allow it as long as there is a sufficient indicia of reliability. Can you talk about that? I see some case law where the dates aren't clear to me of when the restitution was held and whether that statute was still in effect. But there does seem to be case law that's sort of all over the map. And I think it's because of the statute and the timing of that.
Absolutely, Your Honor. To your point regarding hearsay, hearsay is admissible provided it shows a minimal indicia of reliability.
And what is that to you, that latter point?
I would articulate it as being more than just a mere signature. There must be some indicia that it is in fact reliable. And I think the credibility of witnesses and the false facts taken as a whole need to be considered. I would point the court's attention to three cases specifically on that point. That is Love v. State, which is at 338 Southern 3rd 257. That's a 4th DCA case from 2022. Johnson v. State, which is at 856 Southern 2nd 1085, and IM v. State, which is at 958 Southern 2nd 1014.
I'm sorry, but was that initials IM?
IM, yes, I period M v. State. And that's M as in Mike. Now, these three cases stand for the premise that while hearsay is admissible, if there is a proper objection raised as to hearsay, it cannot be used to determine the amount of restitution in a vacuum.
Okay, so that's what I'm wondering is, do you think that these cases came out? Do you think that the statute that governs this now was in place at the time of these cases? Because that's different than stating what you just stated about, well, you can have hearsay unless there's some valid objection. That seems inconsistent with hearsay is allowed as long as it meets some sufficient indicia of reliability.
Well, I agree. There is a disconnect between the statute and the case law. I think the case law is in fact controlling here because Love v. State is a.
Why is the case law controlling?
Love v. State came out in 2022, directly prior to this incident. In that case, is
So is
citing.
it construing the pre-amendment or post-amendment statute?
I believe it's considering the statute has existed at that time, Your Honor. And in that
This
matter,
didn't
No.
provide for hearsay, is that,
I'm sorry, Your Honor,
that statute that it was construing didn't provide for hearsay being admissible?
I do not believe so, Your Honor. I have to look at to double check to be sure. I don't want to mislead the court, but my understanding is this is the law as it was at the time.
Yeah, I guess my question is, so if it's a 22 case, if the incident happened before that, it could have been before 21 when the statute changed. We don't
Correct,
really
Your.
know which form of the statute that they're using.
Correct, Your Honor. And Johnson v. State was a 2003 case, and so was IM v. State was also a 2007 case. That was the first DCA. And again, McCowan v. State as well. That's 46 Southern 3rd 174, 4th DCA 2010.
So those all predate the statute that applies in this case.
I would argue that the statute that applies in this case, the incident occurred in 2021. I would argue that they do apply in this matter. That hearsay should not be considered in and of itself without anything else. And there were numerous objections to hearsay that were in fact laid on the record in this case by the state.
Was this specific argument made though, that this version of the statute does not apply, that allows hearsay if there's a minimal indicia of reliability?
That argument was not raised at the, well, these three cases actually were in fact laid on the record in the trial court level. Love and IM is actually cited in this court's decision in October. It does cite to that case the language in IM v. State says in this case, Greg King did not have personal knowledge of the value of the ruined items, but upon the opinions of vendors who did not testify on remand, written estimates may suffice so long as they satisfy the requirements of a business record. And I think that gets into the state's argument a little bit. In the state's brief, they state that there is, there's always a chance they could have it remanded and come back as a business record. That wasn't done in this case. The matter was continued several times over a defense's objection prior to for medical records provided by the state. And never at any time was there a business record certification that was provided by the state in compliance with 9803 subsection 6.
I guess that's my struggle is what you're saying. If that's true, then okay, grant you, we should remand. But if the statute doesn't mention anything about that, right? The statute permits hearsay as long as there's a sufficient indicia of reliability. So then you wouldn't have to meet a business records exception. And that's what I'm wondering is the statute that appears to govern your case doesn't require an exception to the hearsay rule.
Correct, Your Honor. But the case law that comes after does state that,
It comes out after that statute.
or it comes out, the case law I'm relying on, Love v. State was a 2022 case, Your Honor. The incident at bar occurred in 2021. I do not know the exact date the statute was amended, but it's my understanding that there needs to be more than just hearsay in order to substantiate an award of restitution. I would argue in this case that the facts indicate that where there's nothing else that was shown but hearsay from the defendant. In this case, the alleged victim said he made between $75,000 and $100,000 a year and made about $3,000 to or $2,500 to $3,000 a month with this business that he claims was affected from this incident. I would proffer that because there were no business records, there were no tax returns, anything that would have been used to substantiate that, he's operating off of hearsay. All his knowledge would come from tax returns, business records, any documents that he would have to. He doesn't sit out and count how much money he makes. He gets that from a third party or another source. So that information would be predicated on hearsay.
So every time someone testifies as to how much money they make, they have to bring in a document to prove it.
I mean, I would say their knowledge is in fact predicated on hearsay. They're not the person who makes those records, not the accountants who total that amount of money. They would have to have some sort of document. Otherwise, they're basing their knowledge on an out-of-court statement that's being proffered for the truth of the matter asserted, i.e. how much money I make.
What if it comes from a contract? Like an employment contract, which has an independent legal significance. Case law is legion that says that's not hearsay.
Then that would have to be set on a case-by-case basis. If there is in fact a contract, we have no evidence of any kind of business contract that was provided in this case. So while statements of a contract are technically not hearsay, we have no indication that there was a business contract or anything like that that would have given Mr. Calderon the amounts of money that he made per month or per year, depending however you want to look at it.
He could have personal knowledge of that. It's his business. He
There's,
takes the money from his customers and puts it in his bank. That's hearsay.
I don't believe that testimony came out on the record, Your Honor, in this case. If that's the case, then no, it wouldn't be hearsay. But if he is getting that from a tax return or another document, then in fact it would be hearsay.
Was there cross-examination of the witness that elicited that in fact the source of his testimony was hearsay?
I believe he was just cross-examined on how much he made, Your Honor. I would have to look at the record again to verify. I would turn now to
Was the exact argument with regard to the income, will you remind me at the trial level, was it that would be hearsay? Is that the sole argument that was put before the trial judge
yes, Your Honor.
with regard to the income?
The primary argument was based on hearsay without anything to substantiate it, Your Honor. And again, there's all testimony from Mr. O'Berry. Turning to my third argument, and Your Honors, is the issue.
Mr. Mull, I'm sorry, I want to ask you.
Of course.
Are you aware of any case, other than some of the cases that you cited, any other case in a criminal case or a civil case that documentary evidence is required to prove an element of the crime or the civil act? Testimony is insufficient as a matter of law.
With regard to restitution, Your Honor, no, I do not have any case law that.
Not limited to restitution,
I'm sorry, could you please clarify your question then?
meaning like a crime. So they have elements. Civil cause of actions, they have elements. Are you aware of a case that holds, or a statute that holds, that testimony is insufficient by itself to establish an element.
I would argue or liken this to a felony DUI with two priors, Your Honor, because the case law is very clear that, or the statute actually says you need to have either a driving record or a certified JNS report to bring in those elements. Testimony in of itself is not sufficient. So I would like.
Because the statute said it.
Correct. The statute does mandate that there be a certified JNS report or a prior driving record in order to illustrate the prior DUI for the individual to be convicted of a felony.
Aside from where the statute expressly establishes that that documentary evidence is required, are you aware of a case where the statute doesn't specifically say that, but requires nevertheless documentary evidence to prove that particular element?
Not to my knowledge, Your Honor. Turning towards my final prong here.
You are into your rebuttal time. You can use it how you
Oh,
want.
I apologize. In that case, if I may briefly conclude, for the foregoing reasons, I would argue that this court should reverse the lower court's finding, as there is a lack of proximate cause, but for causation, and the hearsay was the only basis for determining the amount of restitution. Thank you.
Thank you. Counsel, you may proceed when you're ready.
Thank you, Your Honor. May it please the court. My name is Richard Palace. I represent the state of Florida. I want to answer Your Honor's question right off the bat here about any case law requiring solely documentary evidence here. There's none that the undersigned is located. All I have seen in all cases, and being specific here to restitution issues, is competent, substantial evidence. Here, we're looking at relevant material and also admissible evidence is what we're doing, something that will be adequate to reasonable minds to prove a fact. That is our definition of at least competent, substantial evidence as defined by the case law.
Testimony to me seems equal to documentary. I mean, it's all evidence as long as it's
Yes, you're right.
admissible. There could be hearsay issues, things like that, but
And of course, even beyond testimony, direct evidence from testimony or circumstantial evidence in testimony. As referenced in certain DUI cases, certain things need to be certified. When we go into cases such as possession of a firearm by convicted felon or the like, it's required that the actual JNSs or a stipulation, I'm sorry, do not mean to speak in abbreviated terms, but the judgment and sentence are either certified, entered in, found in a bifurcated hearing, or of which there's actually a stipulation to them for purposes of keeping out prejudicial evidence. But here, testimony certainly would work, especially in a case where we are dealing with a majority of this amount being lost income by someone who owns and does the primary work of his business. The victim here was working in a business of building, mending fences. In fact, at the day of the offense, when he was attacked by an appellant, the
Mr.
victim.
Palace, you agree the state bears the burden, correct?
You are correct, Your Honor. The state bears the burden by a preponderance of the evidence. We need to prove
Preponderance of the evidence?
preponderance of the evidence. That is what is listed in the text of 775-089. We must establish it by preponderance of the evidence, and we can introduce hearsay if we have a minimum indicia of reliability.
What's your response to this case law? Do you think that possibly the statute that the incident at the time, like that statute hadn't come out at the time of at the time of the restitution hearing? Sorry, my words are getting jumbled, but I'm wondering if there is a time problem here that's not reflected in the case law, because otherwise the case law does seem to say what he's saying, and I just can't reconcile this with the language of the statute, which leads me to believe it predates the amendment.
Certainly, Your Honor, and to answer whichever half first of that. First, unfortunately, the undersigned did not, of course, brief these arguments, and these weren't brought up below. I know the statute was, the last amendment was 2021. And of course, there's been countless amendments beforehand in 2015 in going forth. I'm not entirely certain under the statutory history of this statute when the hearsay and indicia of reliability was entered in here. It is possible it goes between them. And of course, if this court found this to be a very dispositive issue here, the state would be willing to engage in supplemental briefing.
Well, I guess I was just trying to clarify what the applicable law is. So with regard to the hearsay, I mean, do you think that there has to be some exception in order for the hearsay to come in once the other side objects? Or do you think it's just fair game, almost like a VOP hearing, except then, you can't solely rely on that hearsay?
Well, yes, I don't believe that this is a situation where hearsay cannot solely be brought in terms of the VOP cases. I think all we need is the minimum indicia of reliability. And I believe that's going to be a case by case basis. Again, going into competent substantial evidence being the only form of the standard of review I know of here. And the subsequent form of review is, of course, an abuse of discretion. If reasonable persons could disagree as the trial court's findings here, of course, we are going to find that is not an abuse of discretion in this case. And I think in this case, looking at it case by case, someone actually testifying in detail to what his work entailed, what he was doing and how he was feeling before he was attacked. And then going into painstaking detail in his testimony that, excuse me, Your Honor, that he was unable to engage in this work any longer from the time of this offense, not just to the time of this subsequent battery that allegedly occurred in March, coming before the plea was entered, but in all the time leading up to that, as well as to the time of the hearing where the trial court cut off the future earnings in its ruling.
So his testimony was enough without having to provide documents, and feel free to get your water if you need to.
Oh, I appreciate it, Your Honor. Just needed to clear the throat.
Okay, no
Thank you
worries.
very kindly.
So I think I lost my train of thought, but okay. If his testimony is enough, I was a little troubled by his actual testimony being maybe not the clearest as far as his losses with income. I think he said, I think I've made between 75,000 and 100,000 in a year. There was kind of a range. It seemed a bit vague. Is that enough? Can you assuage my concerns about that maybe the testimony was a little bit too vague for a concrete restitution award on that?
Your Honor, I would assuage that by the worst case, I would argue in terms of testimony being too vague, I think is the Johnson case, if I'm getting these together here. And the Johnson case being where the victim did not testify. We just had the victim's daughter, the victim's attorney, as well as a form that was allegedly prepared by the victim's accountant, but was not, of course. There was no testimony of how that accountant came to those numbers. And in that, they talked about the net worth being somewhere between, I want to say $2 million and in the 750,000. And then the net worth upon meeting the defendant, because I believe that was abuse of an elderly person case. In that case, it had been lowered down to 100,000. That was testified by not the victim, but the victim's daughter, someone who had possibly knowledge into her mother's affairs. But because of that, they found that was speculative hearsay. It was not going to come in. We don't have that here. No one of the victim's family was testifying as to what happened in his business. We don't have someone looking over his books and saying, I think it's this. We have the actual person who runs the business here.
But he couldn't tell us the amount, right? He's like vaguely stating a range.
That is correct that he mentioned between 75,000 and 100,000 at one point. I want to say 4,000 might have found its way into the record.
Per month. I
Per
saw
month.
that
About
something.
per month at another point. And of course, the trial court did not award that amount there. If
What's to make of that? I mean, are those hard numbers? Does the case law require that?
I would here, of course, we need to look into, of course, going into 75,000 a year, that wasn't even necessarily awarded in this case. It kind of seems like the trial court, as they discussed that this went between 20, I recall there was at one point, they said between 2,500 and 3,000 or 2,500 and 4,000. The trial court wanted to go with a different number here. I think that.
Is that permissible?
Well, in an abuse of discretion standard, Your Honor, in a case by case basis, at least with the way we had this case here, I would argue that it is reasonable.
Because she went down, not up.
I would argue it would really need to depend, if we had a lot more detailed statements could have gone up. I think it's important here that, there's a lot of talk of doctor's appointments and the like that occurred after the plea colloquy had occurred in this case before the restitution, but nothing awarded, I believe, was from the dentist office at that time. Nothing of when the soldier surgery had recently been prepared, because I know the victim was in a sling at the time that he was testifying. We, of course, didn't have anything itemized from those to a certain degree. I know some was listed in the memorandum filed by the defense opposing the restitution awards. But I would argue here that the trial court had a lot in front of it as to how it could award this. And I would say that certainly while there could always be more detail, if we're looking at this through the mind of a reasonable jurist and whether reasonable jurists would disagree, here they're saying 75,000 a year. That wasn't even necessarily awarded. We were only awarded amounts for 2 years. The judge went by a 3,000 per month number, and they counted from the time in June of 2021 when this attack happened until when the restitution hearings began in July of 2023, and the judge cut it off at that point. I would argue at a very maximum this court would do, if this court is unpersuaded by that evidence, is just merely remand, possibly for the limited evidentiary purpose of backing up those numbers perhaps more if needed. But it's noted here that going again into whether or not this was from a 1040 or however his business filed its tax returns, even if we argue that is hearsay, we have a minimum indicia of reliability here, because who would know better about his business than the victim who owns this business, who's been working this business all his time, and again, was working this business at the time that he was attacked by appellant. And I want to just briefly go, and we were talking about those cases, and I want to get to the other half of your question, Judge Brownlee, regarding whether or not we are in trouble here with the IM case, the Johnson case, and the Love cases. And I don't think that those cases are, of course, this court has made it clear it is able to, we are only controlled, of course, by the Florida Supreme Court, United States Supreme Court here. We're not controlled by the courts in IM, Johnson, or Love. And I would argue that if this court finds that the statutory scheme is misread in those cases, or the statutory history of the restitution statute was wrongfully looked into, I would argue that this court could rule against those. But even if those cases this court thinks got it right for those particular facts, in the gist of treating like cases alike and different cases differently, I think those cases are all different. IM was about the market value, and the director of the company in that one was testifying to what he was told. He had no personal knowledge of whatever the market value was. And that's very typical in theft cases or any cases that get into property and the like. Fair market value is a big reversal point when we're getting into that. We are not dealing with theft here. We're dealing with battery. We're dealing with battery on a victim who was injured enough that he could not work anymore in his business. Going into Johnson, I mentioned earlier that we did not have the victim's testimony.
So, Mr. Palace, in essence, your argument is, in looking at the case law, that they stand on their own facts. We need to look at the facts here, which your position is here. It's sufficient because the victim himself testified about his business.
Yes, Your Honor. The victim testified about his business. I mean, the victim here already described that he was unable to work when he made his impact statement at the plea colloquy, when restitution was first getting ordered and the hearing was getting sent off. He then went into what his work entailed. I know there was talk, of course, about at the end of or the tail end of Topside here, we were getting into the experts and the like and talking about possible pre-existing conditions and the like. The defendant or the victim here was testifying that he was able to do his work no problem. The most injuries he would normally get is while moving posts or mending these fences. You might get a cut or something while carrying a post on your shoulder, a bruise or some form of abrasion. Not something where his shoulder is now injured, where he's having trouble hearing. and where the man had to take an ambulance ride because of the way that he was attacked. In this particular case, I would argue we have certainly more than sufficient evidence based on the victim's own knowledge of this and how he did this work, how he was capable of doing this work. And he stated, I've had no contracts come in since then. He stated that he's resorted to having to sell property, whether equipment that he had or potentially land. I would argue here that this is what keeps this case out of all of those other cases, including the Love case. While that one might have involved the victim, they were talking primarily about what they paid in attorney's fees regarding, I want to say that was the one about a discovery request case. But with that one, they paid an attorney of it $300 an hour, but there was no testimony in what the attorney went through. It was almost as if we were getting into attorney's fees cases where we need to explain the work that goes into why we're earning the fees that we are and why we say we're paying them $300 an hour and we're asking for $300,000 in attorney's fees. So I would argue all three of those cases are distinguishable, Your Honors. And just to touch a little bit more on our expert testimony here, it was excluded, of course, is not relevant. I think it is very clear. If my physician heard me talk about my pain and didn't do any testing and merely told me, oh, it's just because you're getting older, I'm going to find a new doctor. This would be irrelevant for purposes of this hearing to have allowed Dr. Wiley to testify to this. And further, I would argue that even though the trial court only made its findings on relevance, I would argue sometimes relevance is part and parcel with reliability findings under Daubert. And we certainly don't have principles and methodology testified here or proffered here. And even if those were subject to the proffer, I would argue we have no way that they are reliably applied to the facts of this case without this doctor actually examining the victim here. If this court has no other questions, I will rely on my brief and just in sum, I would argue that we have competent substantial evidence for the amount that was awarded here. And I would argue it was not an abuse of discretion in allowing this particular amount that the court imposed. If this court has no other.
I have
Yes,
a
sir.
question because I'm just still on this hearsay issue. On
Yes, sir.
page 23 of your answer brief, you state, and I understand this is just sort of a fallback thing. This is not your primary position on this, but the last paragraph reads, the state lastly notes that even if this court found harmful error due to hearsay, the state would be permitted to submit this evidence as business records at a hearing with the proper foundation. So
Yes, Your Honor.
you're saying in an abundance of caution, if we find that is required under the law, then the state should be permitted an opportunity to do that and sort of satisfy some exception to the hearsay rule.
Yes, Your Honor. In the event this court finds that evidence, was either speculative or was insufficient to meet what our burden is, the state's asking for this court to remand for the limited function of further evidentiary hearing in getting this evidence in. I believe Johnson allowed that, despite the fact that Johnson's being a case relied upon by the defense here. That case, despite the fact that they found testimony was no good, they were allowing them to have another hearing to actually admit that testimony. I believe that also goes into the Bellet case, which was a main focus here.
My more concern, sorry if I was unclear, was that on remand that you would have to satisfy some exception to the hearsay rule or that it's not actually hearsay. There would need to be something like that rather than just a full restitution hearing where hearsay is allowed.
Well, Your Honor, I would still argue that based on the statutory text here, hearsay is certainly allowed. We would just possibly need to make it clear on the record that we have a minimal indicia of reliability. I would, even though this is not featured in Chapter 90 of our evidence code, I mean, this is a hearsay exception essentially built into the restitution statute. This is only applying here. And here, the text of our statute under 089 is telling us that hearsay may be admitted with a minimal indicia of reliability. It's not like VOP where we can rely on hearsay, but it can't be the only thing. Nothing in this statute says it must be something more than hearsay, just hearsay with a minimal indicia of reliability. And again, with the victim's testimony that we received here, I think that we had more than enough of a minimal indicia of reliability. I think he gave us a maximum indicia of reliability based on his familiarity with his work, what he was capable of doing before he was attacked. And unfortunately, the fact that he was no longer able to continue this business and had to close it down after this happened. So but of course, Your Honor, if this court held that it must be hearsay with an exception, or that hearsay with the exception is the minimum indicia of reliability, of course, the state would be able to admit that evidence at a remanded hearing in the event this court found that that was the way that this case must be remanded. But if this court has no other questions regarding these issues, I will rely on my brief and I ask that you affirm.
Thank you, counsel. You may proceed.
Yes, you are. Turning first to the indicia of reliability, I would point out, as Judge Brownlee has mentioned, there were a lot of statements made that were relatively vague by the alleged victim in this matter. I make between $2,000 and $3,000 a month, between $75,000 to $100,000 a year. If he did in fact have that personal knowledge, he'd be able to do more than just to estimate how much he makes. I would argue that the rule exists under the case law because of that indicia of reliability is very important. If there is something that indicates that, you know, what the person who is proffering his testimony is in fact saying isn't 100% accurate, or there might be some question as to it, I would argue that that raises questions as to the indicia of that testimony's reliability.
But counsel, you agree the whole indicia of reliability only applies if it's hearsay evidence.
Correct. I would agree with that, Your Honor. Turning to the next point regarding the testimony from the victim or regarding his inability to work or lose contracts. This occurred in 2021. That was a year directly after COVID. A lot of businesses were having difficulty in shutting down. There is no testimony proffered by the state that says the contrary. Again, in order to show restitution, there needs to be both but-for causation and proximate cause causation. And I would liken this to DJR versus state cited in my brief, which in that case, a minor had attempted to break into a store and disable the security system. Granted, the security system was in fact re-enabled prior to a subsequent burglary that occurred on the same day or in about the same time frame. But the defendant could not be found liable for the damages resulting from the second burglary. I would say that there is a superseding intervening cause here. The government also pointed out in its argument that there were questions or statements made by the alleged victim regarding his shoulder injury during the plea colloquy. The timeline of events is very important in this case, specifically the order of the batteries and what happened when the hearings. We have the first battery, which is the incident at bar that occurred in 2021. Subsequent to that, we had the battery between the victim's son and the victim himself. The plea colloquy came after that second battery prior to the restitution. I would argue that all that needs to be considered in regard to proving causation, but for causation and proximate cause causation, which I would argue is lacking in this case. All we have are statements after this battery, I couldn't work, or even in the questioning by ASA Scarborough in this matter, she asks what happened after 2021. She says, did your health decline after the battery that occurred in 2021? Again, Mr. O'Berry is 75 years old at this point. And even then, there was no scientific evidence that was proffered by the state to show that these injuries weren't caused by something else, such as age or repetitive motions like with fixing fences. The state had the opportunity to have that evidence with our expert, had he been permitted to testify, to show that there was some indicia of reliability who was saying it could have went either way. That would have gotten to the truth of the matter, which is what we're here to determine today. And for the foregoing reasons, Your Honor, I would ask that this honorable court reverse the ruling of the lower court. Thank you.
Thank you, counsel. This court will be in recess.